Hello again, I'm attorney Robert Flessis for Robbins & Lloyd Career Training Institute. This is course number 8, part 1. We'll be discussing defaults in a transaction, earnest money rules, and the WB-45 cancellation agreement and mutual release form. In this particular video, we're going to discuss defaults. Let's get started. What's the definition of a default, especially when it comes to real estate transactions? Well, it means that one of the parties to the transaction failed to perform on an obligation contained in the offer to purchase. A party could default on any provision that appears in an offer. Well, what are some of the specific defaults that could occur? One obvious default is a buyer's failure to deliver their earnest money. In any contract, the parties set forth the circumstances that could lead to a default and the remedies that the non-defaulting party can seek in the event of a default. The default language in an offer to purchase is found at lines 487 to 501. That provision begins with announcing to both the seller and buyer that they have a legal duty to use good faith and due diligence in completing the terms and conditions contained in the offer. Let's start with good faith. What does that actually mean? It's all about acting honestly in a transaction, being fair and sincere in how you approach and act in a contract. You shouldn't enter into a contract if you're not going to act in a genuine manner. You can't have any hidden agendas or intentions that are deceptive. When acting in good faith, you have a duty to communicate and cooperate. To act in good faith, you're supposed to be truthful and forthright in your actions and communications with the other party. You must treat others fairly and not take advantage of the other party due to their lack of knowledge. You want to be sincere and genuine by engaging in open and constructive communication and work together to achieve mutually beneficial outcomes. You don't want to cause harm to the other party or use undue disadvantage. Now let's talk about due diligence. What exactly does that term mean? You want to minimize risks, make informed decisions, and make sure that you have a clear understanding before proceeding in the transaction. Due diligence comes into play, for example, when obtaining financing or doing an inspection of a property. You're aiming to identify potential risks when making decisions in a transaction. When you employ due diligence, you're informing yourself so you can make the correct decisions when negotiating before and during the transaction. We all know that there are people out there who have no intention to act in good faith or exercise due diligence. I've dealt with clients who wanted me to review an offer to purchase that they unfortunately already accepted before consulting with an attorney. It's basically sign first, ask questions later. That's how it usually works. People get involved in transactions without an attorney because they want to save money. But they're not saving money because when there's a problem and the parties don't work to resolve the issue amicably, then they have to pay an attorney to try and untangle the mess that they got themselves into. I'm sure that you've seen this happen when someone delivers an offer that's too good to be true. No financing contingency, no other contingencies, closings that are set out far in the future. Then, as the transaction proceeds, the buyer wants extensions to the closing date. A buyer that submits that type of offer may not be acting in good faith. It's too good to be true. But people are motivated to unload a property without thinking about the application of good faith and due diligence. If something doesn't smell right, then it probably isn't right. So we've defined good faith and due diligence. Those virtues are required in order to execute and complete the terms of an offer. Now let's talk about default. If one of the parties fails to perform an obligation contained in the offer, then a default occurs. The language in the offer defines a default as a material failure to perform an obligation. What is a material failure to perform? It's a substantial and significant breach or the other party doesn't comply with the obligations, the terms, or requirements that are set forth in the offer. When a party fails to perform a material term in the offer, it then has a significant impact on the purpose of the contract, which is to close the sale. So the term material, when it refers to a breach, means that the failure to perform is deemed material because it substantially impacted the overall goal or benefits that each party intended to achieve through the offer. The buyer intended to purchase the property and the seller intended to what? Sell the property. Now, in many contracts, attorneys will insert stronger language that defines a material breach so it's very clear to the parties. It's defining a material breach so there's no confusion. For example, language like failure to timely deliver the earnest money will be considered a material breach of the contract. Language may also be inserted that allows the breaching party to cure the breach. It could state that the non-breaching party will provide notice to the breaching party of the failure to perform and provide them with an opportunity to rectify the breach within a specific period of time. Here's an example you may have run into. A party has 7 days to deliver the earnest money to a title company that's specifically named in the offer as the recipient. After 8 days, the listing agent realizes that the buyer failed to deliver it. So what happens? In most cases, the listing agent contacts the buyer's agent to alert them to the fact that their buyer didn't perform. The buyer's agent responds, "Oh my gosh, I didn't know that." The listing agent responds, "Can you call your buyer and let them know, then get back with me?" The buyer's agent calls their buyer and is told that they will deliver the earnest money in person today. The buyer's agent calls the listing broker right back and confirms that this will happen today. So you wait, and the buyer, in fact, delivers the money. Problem solved, right? The buyer breached the contract but cured it outside of the contingency period. Is the seller going to go nuts and terminate the contract? Probably not, because they may consider it to be forgetfulness on the part of the buyer and forgive them. Is that a material breach? Probably not, because the seller gave the buyer an opportunity to cure the problem and the buyer promptly followed through. So let's analyze a material breach. You assess whether the failure to deliver the earnest money was material. What was the intent of the parties, and how does the earnest money play into the big picture of closing the sale? This failure was probably a minor deviation compared to the overall obligations in the offer. Well, what if the buyer didn't follow through? Then it would probably be considered a material breach because the earnest money is usually the first item on the list to complete. If the seller isn't going to receive the earnest money, then it may be a sign that the buyer can't perform, meaning they'll never follow through with the purchase and it's not worth getting deeper into the transaction with them. You would offer a cancellation agreement and mutual release for the parties to sign, and we'll talk about that form in part 3 of this course number 8. Now, if a material breach did occur in a transaction, there are remedies to the non-breaching party. In the offer, the language sets forth remedies for either the buyer or the seller. If the buyer defaults, the seller can sue for specific performance, forcing the buyer to perform, which may be impractical, or request the earnest money as partial payment of the purchase price, or terminate the offer and have the option to request the earnest money as liquidated damages, or sue for actual damages. In most cases, if it doesn't look like the buyer will be able to get financing and the offer is essentially a lost cause, you might just want to let them out of the contract by asking the buyer to forfeit their earnest money or a portion of it, instead of getting involved in suing to obtain your actual damages. Taking them to court to obtain specific performance on the contract is probably not going to be fruitful if they can't afford the home and you're going to spend money on an attorney. You balance the equities. Every situation is different, and assessing the remedies for practicality is good to do. If the seller defaults, that might be a different story. The buyer can sue the seller and make them perform, or terminate the offer, get their earnest money returned, or both. You have to ask yourself, though, is the property worth it? If it is, then go for it. Remember, if there's equity in the home, a buyer may have leverage to obtain their damages. There are other remedies available as well. What does the default provision in the offer state? The parties can seek their remedy in law or equity. What's the difference? A legal remedy is monetary compensation for your damages for recovery of your financial losses. Equity is more broad and beyond monetary compensation. A remedy in equity would be to have a court order the seller to convey the property to the buyer. Of course, a court would look to fairness, justice, and conscience. Equitable remedies allow a judge to order a remedy that is in line with the circumstances of the facts of the case. But a judge looks at whether the party seeking the remedy has clean hands, meaning, did that party act fairly and ethically themselves? You learn that kind of stuff in law school. So as a licensee, when a default occurs, you're prohibited from giving legal advice or even opinions to your client. The statute specifically states that you may not provide advice or opinions concerning the legal rights or obligations of the parties to a transaction, or the legal effect of a specific contract or conveyance, or the state of title to real estate. You can only provide a general explanation of the provisions in an approved form to the parties of the transaction at the time of completing the form or when delivering a form for the seller's or buyer's acceptance. This means do not play lawyer. You can play one on TV, but you can't do it in real estate unless you are one. Well, that's it for default. I hope you found it interesting. I'll see you in the next video.